This is our 4 p.m. every Thursday Pacific time at 4 o'clock. And I'm really excited today to have a really special guest, not just because she's an amazing resource and attorney, but actually one that I've worked with and from a couple different angles. Please welcome MinaSirkin. Hey, Mina, how you doing?
I'm fine, Bill. Thank you for asking me to come and join you today. Happy to be here.
Thanks so much.
Thank you for your nice comments.
Thank you. Well, it used to not be so special to see you. I saw you regularly in court, and of course, since COVID, we're there less often or we're on video. So it's nice to see you on the Zoom and all. And I think the thing that I wanted to, the reason I'm excited to have you on, is you're really in a very defined niche within probate real estate. Oftentimes I get asked about referring somebody to a probate attorney as if they're all the same. And the thing, I actually did a video last week on different niches of probate attorneys, and Mina is a probate litigation attorney. So, sometimes there's people who just administer the probate, and that would be a probate administrator. Like, I believe your husband runs that business in your firm, right?
My husband does estate administration mostly.
Estate administration?
Mostly non-probate administration.
There you go. So there's administration of estates, non-probate, and then there's people who, when there's a conflict and there's litigation involved, you need a special litigator. You can't just use any ordinary attorney. You need somebody focused in that area, and Mina is one who focuses in probate litigation. So give us a little background, Mina. How did you end up being an attorney, and how did you end up, in particular, being in probate litigation?
How did I end up being an attorney is a very interesting story. Originally, I wanted to be an architect, and came from an Iranian family where you did whatever your parents told you. You didn't ask any questions. So my father took a look at my portfolio and said, "No, I don't think this is going to work." So he said, "You need to go to law school." And at the time, I think he was involved in some kind of lawsuit. So he said, "Why don't you go try this?" So I did, and here I am. It's now 29 years after I was admitted to the bar. So it looks like it's probably about 32 years since I started law school. But it's been good. I can't complain. I worked for a gentleman who did trust and estate work, and that's all I learned, and that's all I know how to do. So that's sort of the beginning of my career.
So you passed the bar when you were 10 years old. Congratulations. That's pretty impressive.
Yes, I was 10 years old. Okay. No, I was actually 25 when I passed the bars. So
that's still pretty young. Okay, well, either way, that's definitely worthy of a compliment. And so now you say you learn trust and probate from this attorney, but you particularly are in litigation, having worked with you. That's really the area that you focus in, I think. Or how would you describe it, I guess?
So yes, I do mostly litigated cases. Every case usually starts out as a really nice probate administration, and then as you go forward, you realize that there's unusual elements to it, and many of them end up being probate litigation. So you don't know when you go. Well, sometimes you know. Sometimes when you start a probate administration case, you know you're going to have litigants. That's the nature of the family relationships. Usually indicates to you what's going to happen. But many times you don't know. Many times you start a very nice probate by a family member and then end up in many different types of lawsuits within a probate case. So that's always a possibility. But family dynamics govern whether there's an outside relationship, whether or not there's children from a prior marriage involved, or siblings that just simply hate each other because something had gone wrong during their childhood. That usually, those are good indicators that there's a large possibility of litigation in this case, in any case. It happens in trust, happens in probates, happens in conservatorships. All of those feelings kind of work themselves in.
So I say in real estate, nothing good happens the day you open escrow until you close and get the check and the customer gets their proceeds. It can only get worse, never better. my experience in probate says it's the same thing. The longer it goes, even that friendly probate, when it starts, can start to turn acrimonious and, I guess, litigious at some point. Is that your experience with it?
Yeah, well, that's not always true. When you start probate, it can turn good or bad. I mean, just like any escrow would. Sometimes you open the probate and there's no bag of worms. There's nothing unusual, and you go forward and you finish a case after about a year in LA County, and then you're a happy camper. But it's an unpredictable business in the sense that because emotions are involved, we're tied to somebody else's feelings, and we can't always gauge how they feel. I mean, we think we do, but we can't always gauge that.
I think I lost you for a minute there. Was it just me, or was that everybody? Did everybody lose Mina there for a second? Okay.
Yes.
So one more time.
Okay.
I'm sorry, Mina. You were saying how sometimes they start off well, and then sometimes they go sideways. I think we lost you just for a second.
Yes, I think in every probate case, it's possible that you end up with, starting as a nice probate and then it goes sideways. Or you start the probate knowing it's going to go sideways from the first minute you file. So there's those two possibilities. But it's an unpredictable business, because sometimes you have fighting siblings that start out fighting, and then they quickly realize that if they don't stop fighting or they don't mediate, that the only people who end up making money are the lawyers. Right. And unfortunately, in probate litigation, that is a reality. So we tell people, the sooner you resolve your differences, the more money you take off the table.
Exactly. Right. Exactly. It does seem at times that they're just burning through the process of. Like you have some probates that last 3-4 years, and they just spend more fighting than you're resolving anything. So give us an idea. I know in a standard probate, the fees can vary. They're capped based on the law. Can $1 million estate, where maybe it's capped at $23,000 or so. When you get into litigation, though, the legal fees can be a lot more than that, correct?
Yes, there are. So the $23,000 that you mentioned is a gauge of what's called the statutory fee. A statutory fee is a probate that doesn't have anything unusual, doesn't have a court-approved sale, doesn't have anything that results in additional time. There is a second category of fees, which is called extraordinary fee. And extraordinary fees are based on the regular hourly rates of the lawyers. These are for anything involving a will contest, involving finding assets that are difficult to marshal. These could involve interpretation of a will, and many things can cause extraordinary fees. And court-approved sales often result also in extraordinary fees. And the reason for that is the $23,000, while it covers the normal actions, the day-to-day things that we have to do to get to the finish line. So it would cover like an accounting petition or inventories, et cetera. It really does not account for the time that it takes to deal with discovery, lawsuits, filing a lawsuit, responding to a lawsuit, and all of those things. So all of those are extraordinary, including title actions, including title disputes. So many times we go into probate thinking that the decedent owned a piece of property, and then somebody else files an action saying, no, that doesn't belong to the dead guy. That belongs to my uncle, or that belongs to my deceased aunt. Anything is possible. So with respect to expectations of fees, statutory fees would be for a very nice probate. Those don't usually come my way, but they have come my way on occasion. So it depends on the circumstances of the case.
So what do you see is the number one thing or the most common thing that people do that lead to litigation that maybe they could avoid? If you were to sit back and watch somebody in the midst of that process, how would you guide them, or what would you say to them to avoid the time and effort challenges of a costly litigation case?
The thing that there's a couple of things that create litigation is when a parent favors one child over another child. Inevitably, it creates that. When a parent at the end of their life, they get help from one child and they feel obligated to compensate that child for more, that often creates litigation. And when you have a parent who becomes dependent on a child, and that child ends up either transferring assets to themselves or getting compensated more or getting the dad to an estate attorney late in life, that creates litigation. So the thing to avoid is don't favor any of your children over others, even though you may want to. If it's strictly just to avoid probate, don't favor any of them. I mean, because it leaves somebody with a bad taste in their mouth. And if that somebody is litigious, they will start a lawsuit. So that's my only recommendation.
Now, one of the things I've noticed, having seen you in court back when we were able to, gosh, it was a long time ago, a year and a half ago, regularly, was that, a lot of your business was based on other attorneys, that attorneys kind of refer business where there's litigation or they need an independent person or they need somebody temporarily to manage certain things. Do you actively market yourself to attorneys? Is it just the camaraderie of being there in the court? And if so, what do you do now that we're in COVID and not in the court regularly?
It's a combination of the two. I mean, the relationships that I've developed, they have all developed over years. Some of them are strong enough where COVID or no COVID, we all refer back to each other just because the nature of the business is I can't take on everything and other people also can't take on everything. And there's a suitable person for every case. So some of those come, but I do tend to write a lot. I tend to go on talks like this. I tend to Zoom with people quite a bit. So some of those have helped. Television helps. So many of these things all just add together. So for anyone who is looking to market themselves, obviously having a list is important. Not having the list is not helpful. But if you know, for example, that you can call on one of your friends to get you a document, and I see one of my friends right here. I see Scott Greenberg, who I was once going to have a talk with a newspaper reporter, and I called on Scott Greenberg, and Scott Greenberg jumped on it. And even though he's not an attorney, I've known him for many, many years, he was able to get me the documents so I could answer the questions for the reporter. So these are long-standing relationships, that have come and gone over the years. COVID or no COVID, they exist.
The value of a Rolodex, hard to quantify, but it is really one of the critical assets in your business, I think.
So everybody has a niche, so to speak.
So I'm curious about your perspective. I know how I feel. Since COVID initially, things stopped and then they've opened up, but there's the video versus going in person, except for certain things. How do you see the difference of the workflow now? Let's say in the last 90 days or 6-month period, and what do you expect to happen over the next 6 months to a year? Do you have any insight at all?
Well, I can tell you from personal experience that I am not doing the drive downtown anymore. My drive used to be a total of 2.5 to 3 hours a day. Right. But unfortunately or fortunately, that 2.5 hours of free time, which I thought I had at the beginning of COVID, has now converted itself to email time. So what I used to be able to do in person, I can't do it anymore. So I have to do it by email. So the communication has changed, but we get on a Zoom for 5 minutes, 10 minutes. So we have to be better schedulers now. So I now use an app called Calendly. So if I want to set up particular times of the day where I talk to a client or I talk to colleagues, I just give them my Calendly link and they can pick a time. And those are the only times I'm available. So they can see my availability and pick a time. But all of court for me has gone online. So I can appear at 8:30, 9:30, 11, 1:30, or 3 o'clock, but it's more stressful in that sense. But so there's no, when we're in court, if you had an 8:30 hearing and you were done, you'd go into the cafeteria, you'd sit around and unwind for a little while. So now that specific unwind time doesn't exist anymore. And I don't know how you guys do it. I'm pretty sure you have the same stresses as we do.
Yeah, I mean, it's the exact same thing. I wonder, I don't go to court anymore, so I save that drive time. Or even seeing clients assign documents, I save that time. But somehow I work as intensely as ever. I don't know how it went. And like you, I use Calendly and I use a lot of technology. But it is interesting how the energy and the stress of our industry has changed given COVID. So I know that there's certain things you can go to court for. Do you just not go at all? I mean, is there anything that you would go for, make a personal appearance? Trials, do they need to be in person, or is that also all
I've
video?
done trials. Yeah, I've done trials by LA Court Connect, so even that's not necessary anymore. Some sales, it might be necessary to go to court, but they're unusual sales. But usually if there is a realtor who has pre-checked everybody, all the possible overbidders has checked their, cashier's checks, etc., that even going to court on that level is not necessary. So we tell the realtors now that you can ask people to show you their documents before they bid.
Right.
But it's always possible that somebody will show up to court with a check and you have no idea who they are.
Right. And by law, you have
an
to
issue.
allow them, if they're qualified, you have to allow them to bid, or you want them to bid, you're going to make some more money for your estate, right?
Right. And so what we do is we tell them that, if we do, the court usually checks, are there any overbidders that, have not been checked in? We ask them to, send us a copy of their cashier's check by email.
I know in Nevada, in Las Vegas, which is, I think, Clark County, they actually require registering with the court. I want to say 72 hours before. I think it's 72 or 48 hours before. The court actually requires it. Now, I know here in LA, there are some attorneys who request it, or realtors request it, but I don't know that it's required necessarily. It's probably good practice, but it's not the court process. So that's an interesting one that I think the court's maybe missing that would make everybody's life a little easier.
Yeah, it's not required yet, but we have ways to tell the realtors, if you put it on the MLS that you have to present your cashier's check. Most people who come, they come from having seen the MLS. So That's a good way to get people to present their documents to you. It's not any different than anything else. Like you would pre-qualify buyers before they submit an offer, right?
Yes.
In a regular sale. So it's not any different than that.
Yeah. We got one question from Jim Rakowski, who's talking about fees. He says that he thinks California might be unique in that attorneys are rewarded a fees based on the amount of the estate. Does that then create for the attorney an incentive to maximize the value of the estate, or is that and does that work to the estate's benefit or just the attorney's benefit?
But we have a duty to maximize what comes into the estate. So our duty is to the administrator, whose duty it is to maximize what comes into the estate. I'm not sure if that is anymore. So if you awarded me a flat fee, for example, I still would have the same duty at maximize what into the estate, and that's so that it benefits the estate. But sometimes that doesn't happen. And the reason for that is if there is some dispute about ownership of the property, you may think you have $1 million estate, but at the end of the game, you may end up with a $500,000 estate if the estate actually is not the owner of that or ends up not being the owner somehow in settlement, et cetera. So, luck of the draw.
The way you say, and I know because I know you, when you say the word duty, you take it so seriously as an attorney. And I think in general, attorneys take that very seriously. I'm a realtor. I have the same duty you have. I have the same moral, ethical responsibility you have. I also, in some regards, have the same legal obligation, but I rarely hear a realtor say it with the intensity and the meaning that you just said. Speak to me a little bit about attorneys. It just seems, now my father's an attorney, I've been around attorneys my whole life, but it seems to me they take that more seriously than other professions. Is that just my experience, or is that why I want to pick up from that?
I'm not sure. I've had interactions with realtors, with brokers, and we all have rules of ethics we all have to live by. And I think most of the people I've met have dedicated themselves to that profession, so they understand the actual duties of care. So it's more than a duty of care; it's a duty of loyalty that we owe. If you're a realtor in California, you're a fiduciary to your client.
Right.
So that is an issue. I mean, I know you guys can do dual representation, and I know I've seen in forms that you have to disclose the confidential information to both sides if you do dual representation. I always find that interesting,
Yes.
because I say to myself, well, if I'm the seller and if I tell you, Bill, there's I'm not going to take any less than $500,000, and that I have to pay my creditor, for example, $100,000 in 30 days. Even though I'm saying to you I won't take less than $500,000,
Right.
then I might in fact be taking less.
Right.
So how does that put you? Where does that put a realtor who dually represents a buyer and seller? What would you be able to tell the buyer?
I agree with you. 99% of the time, I agree with you. I find it so uncomfortable. You know, generally, you sign the listing agreement first. So you now have a client to sell the house. The other person who calls you isn't yet your client. How can you possibly serve them in any way that lowers to your client that you have a contract with? And my answer to that always is, if my seller would want me to help that buyer, if there's some reason why I can uniquely make it happen, then great. But that's a very rare circumstance. Maybe it's a real small property where other agents won't waste their time on it, or some other reason. But I agree. I don't understand how agents so regularly, and that's why I got involved in probate, to be honest. I saw so many double ending. So how can it be, of all of LA County, that person seems to double end their listings half or 2/3 of the time? It's impossible. There must be something else going on here that's not serving the client, and that became my opportunity. So
Yeah, I'm again, like I said, I don't know, but the duty is there. So it's how you handle the situation. I suppose if that situation arose, I should go to your seller and say, listen, $500,000 your bottom line, but I know you got to pay this creditor. What do you want me to do? Do you let me go talk to them or not? And then if your seller may say no, then that's sort of where things are at.
I would think. I'm with you on that. And like I said, very rarely have I double-ended deals, because I just don't think it's even phone calls on my leads. I like to give them out to other agents, because I just feel like, how can I serve the client? They're paying me good money to represent them, so I understand completely. Okay, so I have some other questions, but I know we have a nice group of people on our call today. Here's a chance not just to talk to an attorney who's involved with probate, but really one of the top, most active in LA County, and also being in probate litigation, really sees kind of the edges of the envelope of the probate business, sees kind of what happens and what can't happen. So if you have questions, feel free to put in the chat box. I've seen a couple. Or if you're watching live on YouTube or Facebook, I see some people. If you put your questions or comments there, I can bring them as well to her. So feel free to jump in. Or if you're on the line and you want to mute yourself and just jump into the question, feel free. So I know Mina. I've seen her in court. She can handle questions, some pretty tough ones. So don't be shy. She seems really nice, but in course she's not very nice if you're on the wrong side.
She's not really nice. I know, but Bill see the ugly side of me in the case. So unfortunately, that's part and parcel of litigation that comes with it. But when I close the computer nowadays, I can't even say I closed the door. When I close the computer, the laptop, then I turn into a different person.
Exactly. Well, it's interesting because I've worked with you. I was thinking about this from three different angles. I've worked with you and your clients, representing your client. I've worked with you on representing a buyer on one of your sellers where there actually was potential litigation or threat litigate, whatever you want to call, opposite sides of the legal battle to some degree. And I've also worked in the middle where I was a realtor for the temporary agreement between the two parties to get a property sold. So I've seen you really from all three angles. I'd much rather be on your side than on the other side.
And the other side that you were on, that drove us crazy, but that's all right. That's all good. It's all good.
Well, and I think also, I won't get into the details of it, but it also, I think that most customers would be shocked to see the variation of the quality of service of attorneys. Now, I know you don't speak about your profession, but the reason why I do this and why I have you on is if I have a colleague who needs a probate litigation attorney, I want them to reach out to you. I don't want them just to pick somebody who has probate on their website because I've seen the difference. And sometimes the difference is subtle. You meet the attorney and you go, wow, this guy looks pretty sharp. And you watch him in court and they're just completely unprepared, and that's not you. So I do think it's important. It's like any other business, the top 10% are so much better than the rest and often don't cost that much more, if any more, that we should always try to find the right person, the right fit. Okay.
When I wanted to get sorry, go ahead.
No, go ahead.
Forgot what I was going to say.
Oh, okay. So tell me about, I know that your husband does the trust administration. Do you get customers who come to you for estate planning? And what are common misconceptions that people don't take the next step and meet with the husband and get started on planning, and they end up down the road being your customer instead of your husband's customers? Because I've had the experience personally of recommending to people to meet with an estate planning attorney, and it's a harder sell than I ever would think it would be. I would think it's an ounce of prevention versus a pound of cure. How do you find that discussion, or do you get involved in that at all?
I generally don't, but remember, when I first started my practice, for the first 10, 15 years, I did planning as well. I tend not to do that now, but in terms of being able to do it, yes, I can. What motivates people to do estate planning isn't usually just somebody telling them to do it. There's usually a reason. Either somebody's traveling and they want to make sure that they've protected their loved ones, or somebody has passed away in the family and it's in the background and their thoughts that, hey, I got to take care of this. Someone's ill in the family, or the person himself or herself is ill. So there's usually these reasons why people do estate planning. Somebody has had a child, perhaps they bought a house. So if they don't fit into one of those categories, their incentive in doing estate planning is small. Not just because they're not aware of it, they're aware of it, but they think, I'll do it next year. There's another more important project on my list of projects to do. So those different incentives, those factual incentives, govern whether or not somebody goes to an estate attorney.
I got a great question from Jim again, and actually it's really relevant to you and me. He says the laws become specialized. How often do you bring in other attorneys that specialize in other areas of law? For example, estate property is tenant occupied and the beneficiaries want to evict the tenant, or a tax attorney. I know you've done that because
all the time.
I was going to say, I just did one with you last week where you brought in
I think
petition action, right?
Right. I had a case that needed a partition attorney, so I brought in a partition attorney. I've had cases that needed eviction lawyers. I've referred out eviction lawyers. Our area of law touches on a lot of things. So we tend to refer out those things that we can't do ourselves, or there sometimes somebody, in our case, somebody else needs representation about a particular topic, or it could be a topic. We can't represent both sides, just like, we talked about a couple of minutes ago, that person's interest is unique to themselves, and I would not necessarily be able to represent them adequately. So that's a case where we would refer out to someone else that can help them.
So I know there are cases where it's an ethical requirement. I also know you well enough to know that you also are quicker than most attorneys to refer to a specialist who's going to do a better job in that area, knowing that that person, is better served and it works out for your business in the long run. Share with me a little bit about your thinking, because I agree with you. I have a client who isn't even a practicing attorney. He has a condo. He's doing his own eviction work. It's like, of all the work to do, that's like the last thing I think I would do on my own. And here you're involved with evictions regularly, and you were quick to refer it out to, a petition action, you were quick to refer it out to somebody who's really sharp, having talked to him, and I appreciate the chance to meet him. Tell me about your thought process behind that. Why is it that you are, not just when you have to ethically, but business-wise or for customer service-wise, why are you so quick to make that referral?
Business-wise, it's really good for us to make referrals out. It gets the job done faster. I would have to go learn partition actions. I would have to go and research it. The person I refer the case to doesn't have to do that. That costs a lot less for the client. It'll make a happier client, and it gets their job done. So, and it creates a camaraderie among attorneys that is very valuable, especially now, like you said, during COVID. Those relationships are very valuable to us. Either we send people out or they send somebody back to us. It evens itself out over a long period of time. So I would not hesitate to refer somebody out. And I'm sure you would do the same thing if you needed to refer to somebody who handles, for example, a San Diego piece of property. Mm-hmm. You could do it, but that person knows the area, knows what's going on in the area, and that person could do it better than you.
When I train new agents, I tell them my license lets me sell the Golden Gate Bridge, but I don't know anything about bridges. So I'd find a bridge expert to let him sell the bridge. But I've noticed it about you, it works both ways. I've seen that you're quick to refer out, and it gives a better customer service or client service experience. And as a result, attorneys are quick to refer back to you because there's that camaraderie that you've earned as a result of being one of those participants in the process. And I guess I'd like to see more realtors do that. I think we're too quick to jump on anything that looks like business rather than trying to find where we create value for our customers. So, great. So you mentioned that you do these kind of interviews and phone calls and Zoom calls and things like that. Do you have an actual, detailed business plan for marketing, or is it just more a matter of you work during certain hours and you put in your time and you do a certain amount of marketing activities? How do you manage your business, the business of your business, as opposed to the legal part? Or do
the business of the business or the actual practice of law?
Right.
So less of my work is the actual practice of law than it is working on my business. Mm-hmm. So most of the things that I do are trying to manage the cases rather than actually work inside of them. So I have paralegals and colleagues that work on those aspects of it so that I can concentrate on figuring out if someone who has called me or sent a referral, if that's actually a good case or a bad case, or how I can actually serve that person. So there are times where I'm talking to people till 9 o'clock at night, and there are times where I've checked out at 2 p.m. So it all varies with, what can be done. I was completely away from the practice of law for a little bit over a month. I had a hip replaced. So I thought wow, that's kind of an interesting experience. I've never had that before, but it sure was interesting because everything flowed without me. So it was not a bad thing.
Isn't it interesting? Isn't it interesting that things flowed without you like that?
Everything flowed without me. Nobody missed me.
When I started the business in 1986, and I got married at the end of that year, and I used to be a 24/7, like many people, like too many people in real estate. And I went away for a week. We went to some resort in the Caribbean where was it? Saint Martin in the West Indies. And then this is before internet, and this is cell phones weren't available like they are now. I mean, I was really out of touch for a week, and it was amazing how every deal closed without me, and I was completely gone for a week. Nobody needed me to be around. Now, business development didn't happen, but I got back,
Yeah.
and it all kind of worked itself out over time. So it's funny how that works out.
So that's a test to see if things will work out, if you're forced to have to do it.
Yeah, yeah, no, definitely. I had that. I had that test this month. I'm religious, so I had 7 days of the 20 work days of September where I had religious holidays, and 2 of the other days I was fasting. So it was like I'm either overeating or not eating anything, and I've never been on the phone or text for 7 of 20 days. But everything worked out, so it's just amazing how somehow I managed to be more efficient during the time I did work. It all worked out good. So okay, so let me ask you one last thing. I guess I would say if you had a magic, if you had a magic, if you had a magic wand. Oops, we're gonna change that. If you had a magic wand and you could change something about your practice, your Marcia, you have a question? No, I think she has her mic open. I'm gonna. She's off. Okay. If you had a magic wand and could make a change in your business and probate litigation or probate in general in Los Angeles County, what would you do? If you had one thing that you could change to make an impact and make the business better or the practice better for other people?
What I could change or what the court could change?
Well, it's your wand. You
That's
can
a
make the
different
court
question.
change it. You can make the court change it.
Okay, so if I had a magic wand, I'd have shorter timelines where they would give you hearings. If that was the magic wand I could have hearings that would happen in 2.5 months as opposed to 6 months. That would be kind of a nice wand, but I don't know if that's a possibility. What else could I do? What else could I do? I think one of the things I would like to work on, which is one of my ultimate goals, is to automate a lot more of my practice so that I can be more hands-free. And that's a challenge because, you would think that the court forms are all the same, but there's really not any two petitions that are identical. So some of those things I would like to be able to see if I can automate, and so that it can run itself with some modification. Mm-hmm. But that's a challenge.
The details of
more automation. Yeah, would be
the details
of
the pleadings, the details of each individual motion. You have to watch carefully. You take a template, but then that almost creates more problems because you might miss something that you have to change.
Yeah, I mean, to give you an example, I mean, I've done a petition to get authorization to sell a conservatee's house many times before, but the facts are always different. Will the court buy my reasoning as to this particular conservatee? That's the part that's not easy to put in a form format, because I think you need to know the circumstances, be able to argue, why the court should grant you that authority. Because the person's alive, they own this home. Why should you sell it? Those are the challenges. But I think that my next set of goals all involves automation.
Interesting. Interesting. Well, we'll look forward to you getting that magic wand and making the process more automated because, I've been in real estate since 1986, and every year we get more automated, but then the regulators create more papers, so we have more forms than before. That with more automation, we're still falling behind in the work we got to deal with. It seems like. So
But you guys have a lot of forms, and we can't read all of your forms.
Well, I always ask attorneys this question after they buy a house. I say, what percentage of the pages that you signed and theoretically approved did you actually read and understand in detail? And I say, when you're an attorney, what do you think the average customer does? Right? They have no idea what they're signing. I feel bad admitting it, and I'm available to answer questions that they get bored after 30 minutes, and you're only on page 12 out of 150 pages of stuff, right? It's just overwhelming to customers.
It is overwhelming for attorneys as well as customers. I'll give you an example. One of the real estate forms that really threw me off one time was, and my client is a lawyer, is a former probate attorney. And we both came across this form. It had to do with fire area disclosures in LA.
Yes, yes.
So we were scratching our heads trying to figure out, is this property one of those properties where there is a risk of fire? Isn't it? Do we have to do anything about it? So these are the challenges that we get. Yeah, even though there were two lawyers and both of us were looking at each other like, okay, now what?
Yeah, and then the customer calls me with a form, and I'm like, I don't know. And I've lived in fire hazard houses before. I've sold fire hazard houses. The one where I was representing the buyer on one of your listings, that was a fire hazard house where the street was shut down at certain times of day when the fire engines had to go up the hill and stuff. That one is a fire hazard. Some of you know. Other ones, how do you find out? It's not so simple. And yet the customer is obligated to disclose if it's a fire hazard zone or not. And I don't know that people necessarily know or how they can even know to know.
It would be very difficult if you live anywhere in the city of Calabasas. Everything's a fire hazard. Correct. I mean, so how do you decipher that? I don't think you can in most cases, but we're figuring it out.
Yeah, and I think sometimes the government, it sounds like a great solution, have people disclose the fire zone, but when the customer doesn't know, they even know what a fire zone is. What do you mean? I don't know anything about that. So yeah, well, there you go. So your magic wand is to automate things so we'll have more forms to sign that we don't know. Automate the forms that we'll know, and let's leave the ones we don't know in manual format. Well, look, we're near the end of our time here. I really appreciate so much the chance to chat with you. If somebody had a question regarding probate litigation, estate planning for your husband, how would they best get in touch with you?
So the best way to give us is to give us a call. It's 818-340-4479, or to email me. My email is msirkin, M like Mary, SIRKIN, @sirkinlaw.com. Or if you can't remember that one, you just type in MinaSirkin @gmail.com and it'll go exactly to the same thing.
Fantastic. And we'll put all the contact
Can you put that on the chat box?
It's there.
Myrna?
It's there. And
Okay.
in the notes in the
Thank you.
YouTube and the Facebook as well. Thank you, Marcy, for following up on that. Good. Okay, Mina, thank you so much. It's always a pleasure to see you, even if it's only via Zoom.
Thank you very much for having me. I
Look forward to
appreciate
seeing you again
you
soon.
calling me.
And happy everybody. Thank you so much. We just Probate Week. We do it every Thursday, 4 o'clock. It's streamed live on the Zoom. When we don't have technical problems, we stream it on the YouTube and Facebook. It's recorded there as well. Thank you for everybody who participated. Call me, text me, or email me if I can help in any way. Make it a fantastic week. Thank you, everybody.
Bye-bye.